Good afternoon. Thank you for joining us today at the Mayflower, and welcome to all of you tuning in via the live stream. I'm Nate Kazmarek, Vice President and Director of the Practice Groups for the Federalist Society. Our program today is sponsored by the Federalist Society's Corporations, Securities, and Antitrust Practice Group. Our thanks as well to the leadership of that group, particularly our Executive Committee Co-Chair Svetlana Gans and Dina Kelly, who was instrumental in putting together this event. This program is really a continuation of a series of great Federalist Society antitrust fireside chats, which we've had over the last 2 years. We've been pleased to host officials from current and former administrations and proudly feature a wide range of views. Next month, we are planning our next luncheon fireside conversation with new FTC Commissioner Melissa Holyoke on May 21st here at the Mayflower. For more info and to register for that event, please visit our website, fedsoc.org. Today, we are excited to host this great conversation between former FTC Commissioner Christine Wilson and Adam Cella. Thank you both for your kindness in joining us for this discussion today. Our guest bios are provided for you all in full on our website, but let me quickly introduce Adam and hand over the program to him. When I was looking up Adam's bio yesterday, the first Adam Cella that came up on Google is evidently a famous MMA fighter. I want to apologize to anyone who RSVP'd for this program thinking a UFC champion was going to be interviewing the former commissioner. But kidding aside, Adam Cella is a friend of the Society and the Chief Counsel for the Administrative State, Regulatory Reform, and Antitrust at the House Committee on the Judiciary. Before the Judiciary Committee, Adam was an attorney advisor for the FTC, and I'm sure you can guess from this pairing who he worked for. Prior to joining the FTC, he was an associate at Axon, Veltrup, and Harkrider. His JD is from Penn Law School, and his undergrad was at George Washington University. As I hand things off, a reminder to our audience that we have set aside ample time for your questions at the end of the panel, so please think of the challenging and difficult questions in advance. Also, please ensure that whatever you come up with ends with a question mark. With that, Adam, the program is yours.
Thank you. I'm going to begin with the standard disclaimer that we're speaking on behalf of ourselves and not on behalf of anyone else. And I'm going to cut Christine's intro short. You all know who Christine Wilson is. I can talk about Georgetown, being a law clerk, being chief of staff of the FTC, but most importantly, you were a commissioner of the Federal Trade Commission. You're nominated by President Trump. You served during the Trump administration into the Biden administration, where you were a commissioner in the minority, along with Commissioner Phillips, and you resigned about a little over a year ago. So let's start there. It's been over a year since you resigned. When you did, you wrote an op-ed in the Wall Street Journal. Part of your resignation, according to that op-ed, was because of concerns over due process and rule of law. Those are serious allegations. Having a year to reflect on that, how do you feel about your resignation?
So first of all, thank you for having me. Thank you to the Federalist Society, and thank you to Adam for agreeing to ask me only easy softball questions, as you can tell. So a year in to my retirement from the Federal Trade Commission, I would say that I have no regrets about taking the course of action that I did. I had spent a lot of time in my last 2.5 years at the commission giving speeches, writing dissents, and speaking in what I felt to be an increasingly strident tone, which is not naturally who I am. And unfortunately, I felt that my objections were not moving the needle sufficiently. And so I took the only course of action that I thought might actually make a concrete difference in the near term. And I was very pleased to see robust congressional oversight of the FTC ensue following my resignation. I think that congressional oversight of independent agencies is an important part of the checks and balances that our framers intended. And the FTC has long had a history of cooperating very closely with Congress, providing requested information, explaining its initiatives, and developing a deep and bipartisan consensus on its approach. And I do hope that that's the response with which you have been greeted.
I agree that congressional oversight is very important, and I would hope that everyone would not just say that they care about congressional oversight, but actually comply with the request from Congress. So you have no regrets about your resignation. So for the last year, there has not been a Republican commissioner. There's only been the 3 Democrats doing largely whatever they want without the voice or the vote of a minority commissioner there. But we are now back at full strength. You were in this position as being a minority Republican commissioner. What are the major roles and contributions that the 2 new Republicans can play over the course of the next year?
So let me say that I am so pleased that Commissioners Ferguson and Holyoke are now there. I do think that the FTC operates best when it has a multitude of voices on the commission. I did staff briefings and party meetings with my colleagues, both with Commissioner Phillips and with Commissioners Slaughter and Chopra, and I felt that I learned from every single interaction. And so I think that diversity of perspectives is very important. I'll use a phrase that Adam heard me use frequently, which is iron sharpens iron. And so I believe that in the same way that Justices Scalia and RBG had a very important relationship, reading each other's statements and opinions and commenting on them, allowed those decisions to be refined, their perspectives to be refined. Obviously, the FTC is not the Supreme Court, but I saw that same paradigm and phenomenon play out when I was there during my tenure when Joe Simons was chair. I think that obviously things changed when I became part of the minority, and I think that there are really important roles for Commissioners Ferguson and Holyoke to play beyond attempting to change votes, because that is unlikely to happen. There are important changes that they can perhaps see made at the margins with respect to which theories are pled, how they're pled, with respect to fleshing out the narrative and complaints so that the public and the business community and counselors can understand the FTC's true concerns. I think that there's a very important role to play with respect to accountability. Obviously, if there are things going on behind the scenes that are non-public, the minority may be limited in how it can bring those things to light. Certainly, you and I spent a lot of time, first of all, trying to figure out all of the shenanigans that were going on, and then once we uncovered the shenanigans, how to alert the public without violating rules against sharing non-public information. So I think that is another important role that they can play. So I think identifying overreach. And obviously, when you look at the non-compete rule, when you look at the health breach notification rule, practitioners understand immediately that there is overreach. But having dissents that say that and that can then be quoted when litigation challenges are brought, I think is very important. We know that courts read the opinions of all of the commissioners. We saw what happened with the Fifth Circuit in Illumina Grail. And the Chamber of Commerce challenge to the non-compete rule actually cites me an embarrassing number of times. I texted Sean Heather and said he should start paying me by the word every time he cites me. And so I think those are some of the roles that they can play, and I think they have come out of the gate really strong. And I am so pleased with the statements that they've made, with the dissents that they have posted, and I'm looking forward to hearing from them on important issues in the future.
So a lot of what you just mentioned, uncovering things that are happening, writing, iron sharpens iron, those I see as commission level issues. But another thing you spoke a lot about and wrote a lot about when you were a commissioner was the staff at the FTC, how professional they are, that they are experts in antitrust law, that they should be listened to, they should be respected, they should be able to do their work. We have now seen 3 years of fairly terrible federal employee viewpoint survey results for senior leaders at the FTC. We also, you mentioned congressional oversight in your first response. The House Judiciary Committee released a report that largely just quoted ordinary course documents and testimony from the managers, the career managers at the FTC, that talked about mismanagement and bottlenecks. And the issue, the big takeaway of the report was that the career FTC enforcers cannot do their jobs. Because of mismanagement, because of bottlenecks, they cannot be aggressive antitrust enforcers. Was that report, in general, did that report cover what you saw at the FTC and what you were talking about when you spoke and wrote about career staff?
So I welcomed the report because, again, I had some difficulty sharing everything that I was hearing behind the scenes. Even when I shared the concerns that I was hearing, I think people perhaps interpreted at least some of my statements as being motivated by politics as opposed to a genuine concern for the staff and for the agency. And so I thought it was very helpful for the report to document again and again and again what the staff were saying contemporaneously in their own words. And the concerns that I shared publicly were the same ones that you identified in the report. And so I thought that was very helpful in terms of driving home the point that this is not about politics. This is about protecting the integrity of an institution that serves an important purpose in the American economy. With respect to the point that you made about potential bottlenecks and whether resources are being devoted in the right ways, we talked a lot in my office about the good to great notion of the hedgehog and where do you have the most impact. Understanding the cold, hard, brutal facts, in that author's words, of finite resources and prosecutorial discretion. And I gave a speech at one point that noted that governing is hard. And there are opportunity costs to every choice that you make about where to devote resources. And are resources being devoted to the issues that have the most significant impact on American consumers? And I think the report demonstrated a fair amount of frustration. Staff felt perhaps resources are not being devoted in the right ways. And with all of the attention that was paid to creating new rules, especially on the consumer protection side, and all of the attention that has been paid to investigating mergers with apparently non-meritorious claims, what is not being investigated?
A related issue you talked about, I want to get to rules, but which you just mentioned, but a related issue before we get there was brain drain, and this has been covered by the press. The amount of people, especially senior managers, that left the FTC. How does the FTC, based on what you saw, recover from the amount of people, especially with a lot of experience, that are leaving?
Yeah, so I think it's an important question. It's one that Senator Lee also highlighted during an AB Antitrust Section Fall Forum a couple years ago. He said, I'm normally not one to worry about the fate of the US bureaucracy, but even I am concerned about the number of people leaving the Federal Trade Commission. And you have at the FTC an unparalleled group of very committed, experienced professionals. And I have always sung their praises, and I will continue to do that, because the beautiful thing about the FTC is it is the little engine that could. It is a small but mighty agency with people who are motivated by the mission of protecting consumers. My assistant, when we were at the FTC, was a woman who interviewed with several different agencies when she first came to the FTC, to Washington, D.C., and she decided to work at the FTC because she fell in love with the mission. It's a mission she could identify with, and so she spent, counting now, 37 years at the FTC because she's motivated by the mission. And so when you lose a lot of people who have experience on the front lines, experience in litigation, experience in rulemaking, experience in investigations, who understand when the rubber meets the road the kind of case you need to win in court, that is a significant institutional loss. I think it's going to take a very long time to right the course for the FTC, but I also wonder who is filling the vacancies that have been made. What kinds of factors are being used in hiring? What characteristics are considered important? I would hope the length of time practicing, the depth of experience is paramount. I would hope so, but I would ask, what factors are considered most important in hiring decisions these days?
Well, the FTC might not have a long time, and the people there, of course, only matter if the FTC continues to exist, or continues to exist as the powerful agency that it is. And what I'm getting with this is the constitutional challenges that there are many that are attacking the FTC right now, too many to list and go through. But you've seen discussion, I think you've touched on this when you were still at the FTC, around plowing forward and taking those challenges on, or managing what the FTC's powers actually are and understanding that you do not want to run the FTC into a position where it is a weaker agency, if it exists at all, when the Supreme Court and other courts are done with it. How would you balance those two ideas of plowing ahead versus managing the risk?
Yeah, I think this is another incredibly important question, and one that I spent time focusing on while I was there. Obviously, there are lots of criticisms that are being levied at the FTC. The Federalist Society, of course, has always been concerned about the constitutionality of independent agencies. The Supreme Court unanimously in AMG decided that the FTC had overreached with respect to 13B. We had a House Judiciary Committee markup a couple of weeks ago on transferring all of the antitrust authority of the FTC over to DOJ so we can add Congress to the list of detractors for the FTC. And so I think, and this is a point that I made when I was there, prudence is important when you are setting the path with respect to individual matters, but also with respect to the broader mission and priorities of the agency. I think a good steward of the FTC would be concerned about navigating these challenges in a way that takes the longer term into account. Unfortunately, what we see instead is, I think, continued overreach and throwing caution to the wind. The non-compete rule negates the statutes of 46 different states and something like at least 30 million private contracts between employers and employees. And I was surprised with the rapidity with which that rulemaking was challenged. And I do think those challenges will be strong, and I think those lawsuits will be won not by the FTC, but by the challengers to the rule.
Well, let's turn to rulemaking then.
Since I've raised it 17
You've
times
already
already.
raised it twice. I know you want to talk about it, so fine. Don't drag me there. Yeah, last week we obviously saw the unfair methods of competition rule, but there are other large, significant rules that are getting attention right now and probably should, that we expect to be coming. The junk fee rule, the commercial surveillance rule, just to name it two. So let's take a step back from the unfair methods of competition rule we just saw, and just what are your thoughts on policy making through regulation at the Federal Trade Commission?
So if you've ever seen me speak before, you will have heard this. I think rulemaking is fraught with danger. I come to that view based on my experience in the airline industry with all of the DOT rulemaking dating back a couple of decades. And the problem with rulemaking, of course, and you wrote me a speech on this, is it tends to look at a marketplace as a snapshot in time. And even before the rule is finalized, the snapshot is out of date, and market dynamics have carried on. And one of my favorite examples is the care labeling rule on the consumer protection side of the house. Unfortunately, the FTC has a care labeling rule that hasn't been updated in years and does not reflect the fact that there are new challengers to dry cleaners called wet cleaners. Who's heard of a wet cleaner? I have one person who also worked in my office who's heard of a wet cleaner because the FTC has not allowed that kind of cleaner to be put on the care labeling rule. And so there is an entire facet of competition that is not being brought to the market because a rule is stifling that innovation and that competition. And so I think the kinds of rules that are helpful are those that require a freer and fuller exchange of information between a buyer and seller, that facilitate more informed decision-making. That kind of rule, count me in. So the old version of the funeral rule, the old version of the franchise rule, the ones that facilitated a spread of information so that buyers can make informed decisions, great. But when we're talking about rules that have broad sweeping reach and that will essentially constrain competition in the flow of information and informed decision-making, not a fan, not a fan. I think I dissented 5 or 6 times on the energy rule.
I think that might be low. I think you had more dissents on that one rule than 5 or 6. And what you're talking about there is all consumer protection rulemaking under Magnus and Mossas, where at least the statutory authority does exist. So let's talk about the unfair methods of competition rule that came down final regarding non-compete agreements. You were at the commission when you were able to, when the NPRM came down, and you did write about that. But now you've had a chance to review the final rule. You started to touch on this, but what are your thoughts on the final UMC rule?
So I think, first of all, yes, there are challenges out there, but businesses need to take this seriously, right? I think it's important for businesses to begin preparing for the eventuality that the rule may go into effect. And so taking a look at the dividing line between the senior employees and other employees is important. If you're continuing negotiations to bring senior employees on board, consider how this rule may impact those discussions. I think that it's an important time for businesses in America to assess the kinds of non-competes that they use. And if you are using them out of necessity, fine. If you are using them out of habit, maybe take a moment to revisit whether there are other ways to achieve the goals that you want. I think we do see strong challenges to this rule, and I would hope that it does not go into effect. But if it doesn't go into effect, then what might happen? I think there are voices in Congress who'd like to see Congress take up a ban on non-competes, and I think there are a lot of states out there that are also interested. And so I think it is a very interesting time, obviously, and a good time for businesses to assess how they use non-competes and whether they need to reassess their practices in the future.
I gave you a chance to talk about rulemaking, so I'm going to shift now.
Thank
Unless you have anything else to say about rulemaking. Another of your favorite topics, though, the merger guidelines, or merger review in general. They were issued in December 2023. You were at the commission and wrote a little bit about the RFI regarding merger guidelines possibly coming out, and you were open to the idea of exploring changes to merger guidelines, since the 2010 ones were over a decade old. Now you've seen the final version. Similar question to seeing the final rule. What are your thoughts on the new merger guidelines?
So I think the new merger guidelines obviously give us a lot of food for thought. I think it's very interesting to trace the final merger guidelines back to the RFI that was issued. There's a lot of similarity there in terms of the issues that were foreshadowed in the RFI. Obviously, there is an emphasis on labor. There is a very disdainful and skeptical view of efficiencies. There are lots of cites to older cases and not so much newer cases. I am not a litigator. I think the big question is how judges will view the merger guidelines, and I look forward to seeing how this issue plays out in court. I'm not a litigator, but if I were a judge, I would expect the advocates to point to newer case law as well. And so I think it'll be interesting to see how judges treat the new merger guidelines.
And the 2010 guidelines were obviously powerful for that reason. And that is not, that is to be determined, whether the 2023 guidelines are a tool for enforcers to use.
Yeah, and the Supreme Court said in Kimball v. Marvel that antitrust is an evolving field, and we do expect, and this is the point that Commissioner Phillips and I made when the RFI was issued, we expect that this is an area where evolution will continue. There is new learning about businesses, there is new learning about the field of economics, and so we expect it to be an evolving field. The question is whether the policies that are staked out are supported by existing precedent and sound economics.
Staying in the merger review space, there's also proposals to change the HSR form, or I should say the HSR filing process. It's going to be, it could be quite a resource-intensive activity just to file an HSR if this process goes forward. Now, there was some recent comments that they're going to pare back what was initially proposed, although with this administration, I tend to take a wait-and-see approach to what they say instead of believing them when they tell me something. What are your thoughts on the HSR filing form and the potential for this to change all mergers?
So I think this is another development in a very long line of developments with respect to merger enforcement that this administration has taken. I think lots of practitioners were surprised and perhaps horrified when the proposal was announced. I do hope that we see some paring back because we know over time, 3% of mergers are scrutinized under Republican or Democrat administrations. There is a continuity there over time. Most mergers are either competitively benign or beneficial. There's a lot of business literature that explains why that is. And so to impose these significantly heightened costs and burdens and expense and time on 100% of mergers is not going to do any favor for our economy. This was actually very pleasing to see that, yes, it was sort of a full employment act for HSR lawyers, but even the HSR lawyers have been quick to say, this is unreasonable, and we do hope that's not the final result. So I believe that if the final rule looks anything like the proposal that we saw, we will see challenges very quickly in the same way that we saw challenges to the non-compete rule. And I do think ultimately a judge would view the changes as arbitrary and capricious based on the evidence that only 3% of all mergers require greater scrutiny. Imposing all of these costs and burdens on 100% of mergers is unjustified.
It's going to be a difficult position for antitrust lawyers to argue against something that's going to make them so much money. But
they've done it, and I'm very pleased about that.
I want to ask you two forward-looking questions, and then we'll open this up to a Q&A from the audience. First, you are now back in private practice after your year off that we discussed. What are you telling your clients about how to deal with the FTC now in this changed atmosphere of heightened scrutiny, or at least heightened rhetoric around the field of antitrust?
So I am on the merger front. I think initially there was a lot of concern about what the agencies were doing, and there was a fair amount of uncertainty. The message now for clients is we have figured out how to handle that uncertainty. And so there are provisions that can be built into merger agreements to allocate risk. You need to plan a significant amount of time to get your deal through the agency. The agencies need to understand, based on provisions in your merger agreement, that you are willing to spend that time and to litigate if necessary. And you have fully planned how to allocate the risk as between the two merging parties. But I think the big takeaway for me returning to private practice is that there is pent-up demand for mergers. Companies are now proceeding with mergers that they had had on the back burner for a couple of years. And there is a game plan and a roadmap for companies to follow in addressing the risk that this new climate presents. And I'm going to talk about rulemaking one more time. I encourage clients, trade associations, think tanks to put comments on the docket for rules that have been proposed, because even if none of those comments are going to be taken into account in the final rule that the commission issues, it is important to have that data, the empirical analysis, the literature cited on the docket so that when court challenges arise, a judge is able to see that the final rule did not take into account and grapple with the full record. And so taking the time to put those comments in the docket is important, even though you will not see immediate results. And then third, I would say, I encourage clients, associations to talk to Congress, because I think it's important to have informed oversight. And so I've encouraged clients to do that as well.
My door's open. I do not need any more meetings on my calendar, thank you. So now I really want you to look into the future. And you mentioned Kimball v. Marvel earlier, and antitrust is not static. It hasn't been for the last 40 years, despite what critics of the last 40 years of antitrust say. It does change, it does evolve based on modern economics and modern law. When there is another Republican administration, what things do you expect to stick from the past 4 years? Or in other words, what is going to stay the same from what happened in the Biden administration, whether that's for better or worse? And if you say rulemaking, I am not going to believe you.
I think the one area of consensus that I saw during my tenure at the FTC, but also across the globe, is a greater emphasis on scrutinizing mergers, merger remedies, and making sure that remedies can withstand the test of time. I think, over the years, the FTC in particular has done a great job at crafting remedies that do withstand the test of time. But I think there has been, for the last 20 years, a growing skepticism of behavioral remedies. And obviously, if there are firewalls, simple, straightforward firewalls, fine. But with respect to more complex remedies, I think that's an area where we saw a bipartisan consensus. So in Lockheed Aerojet, in Illumina Grail, those were areas where the remedies would have been so complex, so many moving parts, so difficult to monitor, that the commission on a bipartisan basis said, we don't think those remedies are going to be sufficient. And so I think in the area of behavioral remedies, there is, in particular, a new and heightened standard.
Thank you. Should we open it up now to audience questions? I know. Yes.
So thank you for all of your remarks today. On the non-compete rule, you spoke mostly to the substance of the rule and how businesses might need to prepare for that. I wonder if you could speak a little bit to the principle of the rule, I guess. So the idea of the FTC, should the rule survive the court challenges, having unfair methods of competition rulemaking authority, combined with the new Section 5 policy statement, which has a very long laundry list of things that are potentially an unfair method of competition, and how that might impact businesses.
So I don't think the FTC currently has the authority to engage in competition rulemaking. And as you can tell from my remarks today, I think rulemaking in general is very bad. And so I don't think it should receive the authority to engage in competition rulemaking. There's an interesting concept that Bill Kovacic and others have talked about, where an agency has very broad authority. You should look very closely at the penalties it can impose and vice versa. And so I think when you couple a very broad interpretation of Section 5 with sweeping ability to engage in rulemaking and potentially to issue civil penalties, I think that's a problem. But I don't think Congress is on the verge of giving competition rulemaking authority to the FTC.
They claim to have it right now, so we will see. But no, I don't expect that to be passed anytime soon, since we just marked up the One Agency Act.
Commissioner, thank you so much for being here. I had two questions. You mentioned merger guidelines, enforcement, and rulemaking. I want to turn to the area of 6B studies. In a recent Open Commission meeting, you stated that there are 3 criteria for a good 6B study. 1, it should be objectively designed. 2, it should be credible. And 3, it should be data-driven. We're expecting the FTC to issue several 6B results in the next few months, and I'm wanting to know kind of your outlook on that, given your dissents in earlier proceedings where the FTC had failed to take a holistic approach and failed to take a soup to nuts approach with regard to its conclusions.
I think the FTC has a long history of using all of the tools in the toolkit, to use sort of a familiar phrase, in terms of informing its policy-making decisions and approaches. I think 6B is an important tool in the sense that you can go out into the market, you can get business information. It's not under threat of an investigation. It's just an exploratory and research tool. And the FTC, following 6B studies in the past, time and time again, has produced very rigorous reports that draw conclusions based on hard facts and lots of empirical data. And so I think that is when the FTC does its best work. There is a heuristic, sort of in the Cass-Sunstein nudge type framework where people develop tunnel vision. My husband did post-conviction review work in Maryland for inmates who had been imprisoned for life. He raised constitutional challenges to the processes that they had been subjected to. And one of the things that he discovered time and time again is that when police and investigators identify who they believe perpetrated the crime, they reject all other evidence to the contrary. And so the result they reach is the result that they had predetermined at the outset was the right one, regardless of all the other information they saw. And it was a ghastly phenomenon in my husband's cases, and it would not be good government to use that approach in policymaking.
I also want to ask you, you mentioned several RFIs in your remarks, and I wanted to ask you about the franchise RFI in particular in light of the FTC's departure from consumer protection to union protection, and wanted to ask your views on FTC's staying true to its mission to, for example, update the franchise rule and kind of do away with its protection of unionization. There was a recent quote from Commissioner Bedoya where he talked about union neutrality. I'm not quite sure what that has to do with antitrust law, but can you please elaborate on your views on the franchise rule in particular and the FTC's franchise RFI?
So I think the franchise RFI was concerning to me at the time because it seemed to be very one-sided. The questions that it posed sought to elicit one set of concerns. And again, going back to my point about tunnel vision in policymaking, I am not sure that that gives us the best outcomes. And to go back to my point about the franchise rule, I think that rule historically has been important because it elicits information from the franchisor that the franchisee can use to make informed decisions about whether to invest. And that purpose is a good and laudable purpose for that rule. And I would hate to see us move into other areas of concern because I think the FTC needs one predictable, credible, administrable standard with respect to competition and consumer protection. Currently, that is the consumer welfare standard. When you attempt to maximize many goals, mathematically it's impossible, and it leads to a lot of uncertainty about what the outcomes will be, which is difficult for the business community to navigate. Makes it very difficult for investment and growth. And so I believe the consumer welfare standard is the right touchstone until someone introduces something better. Sort of the Winston Churchill, democracy is the worst form of government we've ever seen, except for all the others that we've tried. So yes, democracy is messy, but it works. The consumer welfare standard may not be perfect, but I await the introduction of something better.
Commissioner, thank you so much for taking the time today. I guess I, over the last week or two, saw a bunch of rules, including the FTC's recent rule, come out ahead of the Congressional Review Act deadline, and I wonder, did the Congressional Review Act ever factor into rulemaking as you saw it at the FTC, maybe not being up against that deadline? And do you have any thoughts about the vitality of the Congressional Review Act maybe in a future administration vis-a-vis the FTC?
People respond to the incentives that are put before them, right? And I think it's no accident that a lot of rules are coming out now. I think the CRA is important. I know that when President Trump came into office, that was a big topic of discussion, what needed to be examined under the CRA. And so I think it is a good and important act, but people respond to the incentives put before them. Pallavi doesn't have a question?
Great. Thank you again. Nathan, I'll turn it back to you.
Thank you very much, Commissioner Wilson and Adam, for your service, for your insights today. We look forward to having you back at a future Federalist Society event. On behalf of the Federalist Society, we're very grateful. Please join me in thanking them both.